If everyone could please find a seat, we're going to start the program in just a moment. If everyone could please find a seat. Good evening. Good evening, Ms. Carter. Good evening. I'm John Miko, the Executive Director of the Union League Legacy Foundation. It's my great pleasure to be with you for tonight's Jack Templeton Liberty Series. As you know, the Legacy Foundation is the nonprofit charity of the Union League. We use the history, the values, the spirit of this great institution, the Union League of Philadelphia, for all sorts of programs that support the first line in your bylaws. Every member shall support the Constitution of the United States, and certainly no better program than tonight's could do that. So I'm looking forward to a wonderful program. Thank you to all of you who support our work. It's only made possible through your contributions. If you haven't made a contribution yet, it's never too late. We're just starting our year. Had 2 league members come up to me and say, is it too late? I said, no, we haven't even sent the letters. But if you want to save us some postage, please just see me or Kristen Moran. We're happy to accept your gifts. Thank you to all of you who support our work. So tonight's program, as usual, will go about an hour. I'm going to ask if you could please turn off your cell phones. Take a moment to do that. We will have Q&A at the end. We will use the note cards. So please, if you have a question, simply fill it out on the note card. There will be staff that'll come around during the program to collect your questions. And now to introduce our program is Mr. Jim Dunnigan, the chair of the Legacy Foundation and one of the great leaders of the Union League. Please welcome Jim Dunnigan.
Thank you, John. Good evening, everyone. It is my pleasure to introduce our program panelists tonight, 3 of the leading constitutional scholars of our time, Jeff Rosen, Robbie George, and John Yoo. Jeffrey Rosen is the president and CEO of the National Constitution Center, a nonpartisan nonprofit whose mission is to increase awareness and understanding of the U.S. Constitution. Rosen is also a professor at George Washington University Law School and a contributing editor of The Atlantic. He was previously the Legal Affairs editor of the New Republic and a staff writer at the New Yorker. Rosen is the author of 6 books, including most recently Conversations with RBG, Justice Ruth Bader Ginsburg, on life, love, liberty, and the law. His other books include biographies of William Taft and Louis Brandeis. Robert P. George is the McCormick Professor of Jurisprudence and director of the James Madison Program in American Ideals and Institutions at Princeton University. He has served as the chairman of the U.S. Commission on International Religious Freedom, and before that on the President's Council on Bioethics, and as a presidential appointee to the United States Commission on Civil Rights. He has also served as a U.S. member of UNESCO's World Commission on the Ethics of Scientific Knowledge and Technology, and is a former judicial fellow at the Supreme Court of the United States. And lastly, John Yoo is the Emanuel Heller Professor of Law at the University of California at Berkeley. He is also a non-resident senior fellow at the American Enterprise Institute and a visiting fellow at the Hoover Institute at Stanford University. He has written 10 books and more than 100 articles on the subjects including national security, constitutional law, international law, and the Supreme Court. He regularly contributes to the editorial pages of the Wall Street Journal, New York Times, Washington Post, Los Angeles Times, and the National Review. Ladies and gentlemen, please welcome Jeff Rosen, Robbie George, and John Yoo.
Can you hear us all okay?
I think it's feeding back, John.
So we'll feedback. Okay, good. How's that sound now? A little louder? It's usually not my problem. Are we okay now? Oh, there we go. That sounds better. Well, it's a great pleasure. Sorry. It's a great pleasure to be with you all and to be with such distinguished speakers. In addition to the introduction, I just want to say it's wonderful to see Jeff. We were in law school at the same time and we had the same teachers. Somehow those teachers produce people with totally different outcomes, which is a great feeling on teachers with teachers everywhere. And I was so happy when I learned he was going to be president of the National Constitution Center in my hometown of Philadelphia. It's great for Philadelphia, great for him. And believe it or not, he's been the head of the Constitution Center now for 10 years. This is his 10th year. Lucky me. And, before he was the head of the center, he was, I think, widely recognized as probably the most read legal commentator and journalist in the country. So it's great to have him. And then Robbie George is, I think, for many scholars, the model of how to be a great scholar. He's a person who has been described by people on the other side from him as being one of the great moral theorists of our generation. That was by some, I think, no less than Justice Elena Kagan said that about you. Oh, sorry, we're getting terrible feedback. Sorry. And has been a wonderful example, not just of a theorist, but someone who puts his ideas into action. I think one of the most significant things he's done as a university professor, which is a model for us at Berkeley, unfortunately, is he created the Madison Program at Princeton, which seeks to provide a forum where people of all ideological views can come and hear speakers. We copied him at Berkeley and created one out in California because it was such a model, and it's been spreading to a lot of our top universities. And so he's, again, been an example of someone not just a great scholar, but someone who's made the university a better place for all of us. So next time your kids come back from college and give you a hard time, it's his fault. So we're here to talk about the Supreme Court. The last 2 years, I think, have been some of the momentous years in the history of the court, certainly maybe in our lifetimes. So I thought we would talk about three things. One, their thoughts and impressions of these last 2 years where you've had the reversal of Roe versus Wade last year. This year, you had the reversal of affirmative action, both policies upheld by the Supreme Court for 50 years. And then we'll talk more specifically about this Supreme Court term that just finished and looking at the future of the Supreme Court. You just saw maybe that the court not willing to let itself sit on the sidelines, just to announce that it will hear the constitutional rules that apply to all social media companies in the country. And then we'll, I think, end with a discussion, because not only are they both lawyers, but they're also both people who've been observers and participants in politics. ask what they think about the heightened attention and controversy about the Supreme Court in the political sphere. So, Robbie, why don't we start with you? What are your thoughts about these last 2 years of the court, all these changes and all these major doctrines? Is it just the court doing what it's always done, or is this actually a significant change? And what do you think of it?
Well, thank you, John. And let me thank my friend John Miko, and Jim, thank you for the opportunity to be back at the Union League under the visage of our great President Lincoln. And what a treat it is to be on the program with John and Jeff. It was Madison, my man, John, who famously and accurately said, in speaking of the new republic that they had founded, he and his fellow founders, who said, only a well-instructed people can be permanently a free people. That's so true if you think about it. If you're going to be a self-governing people, and in that sense, a free people, you had better be a well-instructed people, because you're in charge. You're governing yourselves. And what do you most need to be well-instructed about? The circumstances and principles and institutions of our civic life. For us, the Constitution, both the big C Constitution, as in National Constitution Center, and the small c, the larger Constitution, the set of informal as well as formal arrangements by which we govern ourselves. And this is a constant challenge, has been from the beginning, will be for as long as this great experiment in ordered liberty and Republican government goes on. The big challenge is making sure that our people are a well-instructed people, a people who really do understand our Constitution. And there's simply nobody who does more toward the goal of instructing our people than Jeff. The work that he does at the National Constitution Center is the most important work in civic education that is being done in the country. And I commend John for the very same reason. John doesn't just sit in his office at Berkeley and do his scholarship, although it'd be a great contribution if that was all he did. But John's not only teaching his students, he's out there in the public arena, on television, on podcasts, actually instructing people, engaging in debates and discussions, but helping our people, whether or not they're law students, whether or not they're formally his students, to understand the principles and institutions of our civic life, the principles and institutions of Republican government. So I consider it an honor to be with these great educators in the richest and best sense. So John asked me about what I think about these 2 years. Is it really as momentous as it's sometimes depicted to be with Supreme Court decisions and what's happened at the court? Or is this nothing new? The answer to both questions is yes. It is momentous and it's nothing new. The history of the Supreme Court of the United States is a history of momentousness, of big stuff and big changes, stuff that makes a profoundly important difference to our civic life. This might have surprised many of our founders, not all, but it might have surprised many of the founders of our country, because many expected, in the famous words of Alexander Hamilton in Federalist Paper number 78, that the judicial branch would be the least dangerous branch, that it would be the weakest of the branches of government, the least influential, possessing neither the power of the sword, who's got that? The executive. Possessing neither the power of the sword nor the power of the purse. Who has that? The legislative. What does the court have? Only judgment, Hamilton said. So it will always be the weakest. It's the one from which, the branch from which you would least expect momentous stuff to happen. Least expect to have a big impact on the nature of our civic life and the terms and conditions under which we live and cooperate with each other. But the reality is that almost from the beginning, the Supreme Court has made a big difference by issuing momentous decisions that were controversial. In 1803, Marbury against Madison, the case that we traditionally think of There are nuances that Jeff and I could get into, but we traditionally think of as the case that created or introduced judicial review of legislation, the authority of the court to invalidate legislation as unconstitutional. 1803, it's pretty soon after the Constitution was itself ratified. The court hands down this momentous decision, which was not accepted by everybody. President Jefferson, for example, thought that the decision was an outrage. And then, of course, only a decade plus later, the same Supreme Court, the Marshall Court under Chief Justice Marshall, hands down the momentous decision in McCormick against Maryland, determining in very important ways what the relationship of our national government to our state governments would be. Critical question, important question, momentous decision, very controversial. Those who favored the stronger national government thought it was a great decision. Those who thought the national government needs to be kept in check and the state government authority needs to be protected against encroachments by the national government, they weren't so happy. And then by the mid-1850s, with the conflict over slavery reaching the boiling point, we get the decision in Dred Scott against Sanford. A huge momentous decision. Many of our greatest 19th century historians, the great Alan Gelso, my colleague at Princeton, great James McPherson, another of my colleagues at Princeton, many of the great historians of the era say that decision actually precipitated the Civil War. And there's been nothing more momentous in our national history than that fratricide. Or once we're into the Industrial Revolution, the 1905 case of Lochner against New York, striking down New York legislation, limiting the number of hours that workers could work in industrial facilities like bakeries to 60. Another very controversial decision. And we could go on and on. Now, in two of the big decisions we got from these past couple of years, the affirmative action cases and the abortion case, as John Yoo pointed out, we had a reversal of course by the court. The court overturned previous decisions. That new and unprecedented? No. It's happened more than 200 times in our nation's history, and not just on small, trivial, minor things, on big stuff. Lochner against New York, that 1905 case, striking down the labor protection laws from the states, that was reversed in 1937 in the case of West Coast Hotel against Parrish. A very important civil liberties case from 1940 having to do with a school board or state school officials requirement that students salute the flag, even if saluting the flag was contrary to their religious convictions. The case involved Jehovah's Witnesses students whose families held that saluting the flag was a violation of the Bible's prohibition of worshiping graven images. Well, originally in the 1940 case, the Supreme Court of the United States upheld the legitimacy, the constitutional permissibility of requiring students, even against their parents' religious beliefs, to salute the flag. Just 3 years later, in the case of West Virginia against Barnett, 1943, the Supreme Court reversed course, changed course. The Supreme Court originally upheld de jure segregation. That was the case in the 1890s of Plessy against Ferguson, establishing the doctrine now discredited of separate but equal. You could have separate facilities. You could mandate separate black and white train cars so long as they were equal. Never were equal, but that was the court's ruling. Well, that gets reversed in Brown against Board of Education in the mid-1950s. So, John, momentous, absolutely momentous. The affirmative action cases, the abortion case, very momentous. Unprecedented or new or just more of the same? Actually, not unprecedented, not new. In very important ways, more of the same.
Jeff, more of the same, or has this been a real change in the court, or do you agree with Robbie? It's actually what the court's been doing for a long time.
Wonderful. Well, first of all, it is a joy to be here at the Union League, where I spend so much of my time in Philly. It's such a delight to be here with my old friend and classmate, John Yoo. And the pleasure that John takes in coming home to Philly is just infectious. And it's always great to give him an excuse to do it. So let's keep inviting him.
When the Eagles are winning.
Absolutely. And your mom is here as well. And we have to give a round of applause for John's mom. Hooray. The whole point of appearing on panels is to make our moms proud. So, and to be here with Professor George, who has spread so much light in his extraordinarily inspiring teaching about the Constitution. We're so fortunate to have his insights at the National Constitution Center, where he appears on our videos teaching high school kids online. And he's also done so much to educate the new generation of lawyers, including conservative lawyers who are at the center of the debates over textualism and originalism today. So at the Constitution Center, as those of you who've joined our programs know, I always begin our programs by reciting our inspiring mission statement. The National Constitution Center is the only institution in America chartered by Congress to increase awareness and understanding of the Constitution on a nonpartisan basis. And that sacred nonpartisan mission means that we convene liberal and conservative voices to explore areas of agreement and disagreement about all areas of the Constitution. So on the weekly We the People podcasts and on the town hall programs and on the Constitution 101 classes that Professor George has appeared in, we bring together disparate voices to explore areas of agreement and disagreement. I want you to check out those incredible resources to educate yourself about the Constitution and to make up your own minds. This means I have the unique role of moderating discussions, but it's unconstitutional for me to express any of my own opinions whatsoever. And therefore, I'm in a bit of a pickle. How can I describe in a completely neutral way that all of you will find utterly descriptive and nonpartisan the incredible momentous time we're in? I'm going to try to do it, and I'll agree with Professor George that this is both momentous and that it's happened before. I would say that there have been four great eras in our constitutional history. First, the founding. Second, Reconstruction. Third, the New Deal Roosevelt Constitution. And fourth, the Reagan Originalist Constitution. And in each of these eras, vigorous voices have come to contest the previous constitutional understanding and have transformed the Constitution through civil war, through judicial appointments, or through political activism. So, as Professor George said, the founding consensus was shattered by the Civil War and a disagreement about whether or not the South could constitutionally secede, and the Reconstruction Constitution, founded in the 13th, 14th, and 15th Amendments, asserted the supremacy of the Union. Then in the Progressive Era and the New Deal, FDR insisted that the scope of federal power had to be expanded to create an administrative state and to protect civil liberties, and his New Deal Constitution was ratified by the New Deal Court and the Warren Court. Starting in as early as 1966, but a centerpiece of his presidential campaign in 1980, Ronald Reagan came to office pledging to resurrect the Jeffersonian vision of strict constructionism that he felt had been betrayed by the New Deal, pledging to appoint justices who would interpret the Constitution in light of its text and original understanding, to roll back the excesses, as he put it, of the New Deal administrative state, as well as judicial decisions, including Roe v. Wade, that he felt had betrayed the original understanding. And although he nearly achieved a Supreme Court majority in 1987 with the appointment of Robert Bork, Bork's rejection meant that he had to wait another 20 years for the appointment of Justice Barrett to solidify an originalist majority on the court. And 2 years ago, with the appointment of Justice Barrett, we now have a supermajority on the court, 6 justices committed in different ways to interpreting the Constitution in light of its text and original understanding, and committing to doing exactly what President Reagan pledged, which is to roll back the perceived excesses of the New Deal administrative state and to reverse decisions like Roe that they felt were a violation of original understanding, and that's just what happened. So how did I do? That's completely neutral. No one could possibly object to anything that I just said. Now, and we see that this is indeed momentous and historical. 4 constitutions in American history, the New Deal Reconstruction, the Roosevelt and the Reagan Constitution. This is indeed a historic, momentous sea change in the court's understanding of the proper scope of federal power and how to interpret the Constitution. Now, what to make of it? And now we have to get to the crucial question of constitutional methodology. President Reagan pledged to appoint justices who would interpret the Constitution in light of its text and original understanding. However, the justices on the court appointed by Republican presidents differ in significant ways about how exactly they consider themselves to be textualists and originalists, and how they view the appropriate role of tradition as well as of precedent. So at the NCC, in our Constitution 101 classes, which we're actually trying to bring to middle school students, believe it or not, as well as high school students, we teach the 5 methodologies of constitutional interpretation. First, text. Second, history and original understanding. Third, tradition. Fourth, precedent. Fifth, structure. Sixth, natural law. And you can check out the videos to geek out on the details of them, but they're at the center of the debates that are going on in the court now. And just to, again, try to do this as descriptively and quickly as possible, there have emerged a significant difference between and among the 6 conservative justices, in particular among 3 textualist justices who say that the Constitution should be interpreted primarily in light of the text as the words were understood when they were ratified, and those justices more interested in original understanding and tradition, who think that not only the original meaning of the provisions and the context in which it was justified are relevant, but also tradition over the course of American history, not just at the time of the ratification of the Constitution. And the 3 textualist justices, Justices Alito and Thomas and Gorsuch, differ in significant ways from the more originalist and tradition sympathetic justices. Text, history, and tradition is their touchstone, and those are Chief Justice Roberts and Justice Barrett and Justice Kavanaugh. And to take the most dramatic example of this split, think about Moore versus Harper, the elections case last year. This was described by Judge Michael Ludig as the most significant test of judicial power since Marbury versus Madison. He said it was a huge case. And just again, to describe what was going on quickly, the claim was that the Constitution, which gives state legislatures the power to determine election procedures, meant that the legislature's power was exclusive, and that state courts could have no role in interpreting contested elections. So remember, in Pennsylvania last time around, we had a big dispute about whether or not to count late ballots in Pennsylvania. And if the challengers had succeeded, and legislature meant legislature, then Pennsylvania courts could not have decided whether or not to count the ballots. And indeed, in theory, the legislature could have changed the election results and decided to give the election to President Trump rather than to Joe Biden, because the legislature's power was primary. It was a very strong claim rooted in the text of the Constitution. The Supreme Court, by a vote of 6-3, rejected the claim. The 3 text, history, and tradition justices joining the liberal justices to say, this is not persuasive as an interpretation of the original meaning of the elections clause. At the time of the framing, it was obvious that state courts had a role to play in interpreting the results of elections. Framers said that they should. There were lots of examples where they did. And to take this word legislature out of context would be to do a gross violation to the intent of the framers and radically to change American elections. And they were joined in that result by the liberals. So that's just one really dramatic example of how text can lead to a very different result than original understanding if you're not looking at the context. And I know on this next round, we're going to run through the big cases, but I'll share with you then how whether or not you're just looking at the text or whether you're also looking at text history and tradition can determine which way you come out in affirmative action and all the other big cases. And I'll just end this thought to say, Professor George has indeed inspired the new generation of originalist scholars who are debating vigorously among themselves about which side to come down to in this important debate. We had a great Constitution Center panel recently with, I think all three of them may have been your students, but Sharif Gurgis and some other great scholars were disagreeing about when to look at history, when to just look at text, when to look at tradition. Nothing wrong with that disagreement. That's exactly what lawyers are meant to do. And this is all done in vigorous good faith, but it makes all the difference in how you come out. And the liberal justices, I should say, are charging the conservatives with being opportunistic, with switching among these methodologies, text, history, and structure, in order to reach their preferred results, playing whack-a-mole, as Justice Kagan has suggested in some of the cases, with whether or not they're looking to history or tradition or text in a result-oriented way. So that's the nature of the debate. It's really interesting. It's really dramatic. You've got to dig in. It took me a while to describe the methodologies. And when we talk about the cases, you'll see that you need to read the majority opinion and read the dissent in order to make up your own mind about who is right. And that is what I'm going to urge you to do always, rather than assuming that it's all conservatives against liberals. Take the time to read the opinions so that you can engage these debates and make up your own mind.
Great. Oh, by the way, there are, you all know this already, but there are index cards. If you have questions, please write them down, hand them to Kira, and I'll try to reserve like the last 15 minutes to, we'll do lightning rounds. All right, we're just gonna ask them like 3 at a time, see what happens. But to follow up now, let's talk about the Supreme Court term that just ended. There were 3 major decisions, I think most people would say. First one, we've already referred to, the case against Harvard and University of North Carolina, ordering the end of the use of race as a preference in college admissions. There was a second case called 303 Creative, which was about whether the state of Colorado could require a wedding planner, website designer to work for, not to work for, but to create websites for gay marriages, which ran against her deeply held religious beliefs. And then the third major case was a rejection of the Biden administration's cancellation of student debt throughout the country, which the court concluded Congress, Robbie had mentioned Congress is in charge of the purse. The court essentially held that Congress had not given the president the right to use the purse in that way. First, because going back to Robbie, do you agree with these decisions? Do you think that the court used this, right, the least dangerous branch power in the right way in these 3 cases? Or was the court getting too deeply into politics, which is the criticism here today in a lot of outlets?
I actually do agree with all 3 of the decisions. I think the middle one you mentioned is actually pretty clear, 303 Creative. I think the other 2 are closer cases. The most important one, I think, for the nation was the affirmative action cases, the Students for Fair Admission cases with North Carolina, University of North Carolina, and Harvard being the parties in the 2 cases. There you have the question of what the original understanding of the Equal Protection Clause actually was. Was it an understanding that required color blindness as opposed to racial consciousness or race consciousness when it came to the exercise of governmental power? That, I think everybody should admit, is not crystal clear from the historical record. And all we can do is our best to sort it out. If we already committed to the idea that we should interpret the Constitution where it's not clear as a matter of text, at least sometimes, or at least in part, on the basis of the original public meaning. The court, in the opinion for the court by Chief Justice Roberts, pointed out that this doesn't mean that race can never be mentioned or taken into account in any way in admissions, but it can't be used just in itself as a factor favoring a candidate for admission or disfavoring a candidate for admission. It can figure in the following way. If a student is telling his story, the story of the challenges, or a prospective student is telling the story of the challenges that he faced growing up, getting to where he is, he might talk about the challenges having to do with his social class. He might have talk about challenges having to do with perhaps a disability, dyslexia or something like that, that the student had encountered and overcome. You could also, if you're a student who experienced racial discrimination, for example, or some other challenge as a result of your race. Let's say you were the only Native American Indian student in a group that was overwhelmingly of another race or ethnicity. You could talk about that challenge and you could bring race into it, and the university could fully take that into account and credit your overcoming that challenge in your favor. So I do think at the end of the day, the court was right, although it's a close case, to adopt the position of the dissent by Justice Harlan in Plessy against Ferguson, and to treat the equal protection requirement of the 14th Amendment, provision of the 14th Amendment, as requiring color blindness. But even having said that, that doesn't mean that race can never be mentioned in applications or can never play a role. 303 Creative seems to me pretty straightforwardly to be a compelled speech case. West Virginia against Barnett should have taken care of that. I was surprised that it was as controversial as in fact it was. The third case, the case about student debt and cancellation of student debt, is not a question about the constitutionality of the cancellation of student debt. Whether you think the cancellation of student debt is a good policy or a bad policy, it is constitutionally permissible to do it. The question is, who has the authority to cancel the debt? Is that authority vested in the president or is it vested in the Congress? If we agree that it's vested in the Congress, what does Congress have to do to authorize it? Or what does Congress have to do to authorize the president to do it? Or can Congress authorize the president to do it? So it's a case that I think is very confusing to the general public, because of course they're focused on the policy itself. Should we cancel student debt or not? Did the Supreme Court allow the cancellation of student debt or not? And that's actually not what the debate is about. It's about the constitutional question of who has the power, not what the policy should be.
So Jeff, same question to you, but you've done a really good job not taking any positions. But since we were in school together, I know you wrote a paper saying that the original understanding of the 14th Amendment justifies racial affirmative action. So you are on the record on this one. So what do you say in response to Professor George?
Busted.
Now, the problem is you had to be friends with Jeff for 30 years.
Absolutely.
Something like that.
And read a lugubrious paper. I do believe that the original understanding of the 14th Amendment did not include schools as being covered by the privileges or immunities of citizenship that were subject to a colorblindness requirement. And therefore, for a strict originalist, Brown v. Board of Education was wrongly decided. The 14th Amendment says that not all rights, but only civil rights or privileges or immunities of citizenship are required to be extended to all citizens on equal terms. And the framers of the 14th Amendment didn't think that the right to go to school was a privilege or immunity. They stood up in Congress that proposed the amendment and said so. Don't worry, you can pass this amendment, schools aren't covered. And that's why Brown versus Board of Education is a big problem for originalists, because it is not clearly consistent with original understanding. Now you can address that question by asking what the original understanding was in 1875 rather than 1868, as Professor Michael McConnell has done, or moving to a higher level of abstraction and saying maybe schools weren't a privileges or immunity back then, but they are in 1954. But that's not asking what the text meant when it was ratified, and it's also not asking what the original public meaning of the text was when it was ratified. So therefore, although I think Brown was right, because I'm not a specific originalist, I do think this is a problem for Justice Thomas, as well as for Justice Gorsuch and Justice Alito. Now, they have addressed this in the affirmative action case in a really interesting way. They said, we don't have to look at all that messy history about whether or not schools were covered, or whether or not the Congress that created the Freedmen's Bureau did or did not extend benefits to white citizens, as Justice Thomas was debating with Justice Jackson. They said, because the text is clear, it's colorblind, and therefore we don't have to look at the history. And you ask me what I think, I do have to say that seems to me not intuitively obvious, that the text clearly requires colorblindness. After all, this was the most contentious question in our constitutional history since the text was passed, and many, many people felt that it didn't require colorblindness, including those who framed and ratified it. And therefore, to just kind of say, debate over, this is obviously a colorblind provision, I would say it doesn't seem to me persuasive as a matter of textualism either. This is an important, you ask, I'm happy to share my reaction to this, because this is a significant move which emerged for the first time in the affirmative action case. People have spent certainly more than a century, but many decades since the originalist movement began trying to reconcile Brown with Board of Education and trying to figure out whether or not affirmative action is consistent with it. And just to sweep all that away and say we don't have to address the history because the text is clear, seems like an example of kind of a very strong form of textualism, avoiding the necessity to look at original understanding. And that's why I completely agree with Robbie that it's just a hard case, and much of it depends on at what level of abstraction you want to look at the history, at what period of time you're going to look at the history, and to what degree you think the history trumps the text. So for such a momentous case that was so important and is really, the centerpiece, it's kind of a touchstone for originalism, I would have hoped for a little more acknowledgement of the complexity of this case, as well as defense for why text gets to trump history here. The 303 Creative, viewed as a compelled speech case, could be seen as a narrow application. Only website designers and other business people whose work has an expressive content can claim an exemption from having to abide by public accommodation laws. In other words, artists and website designers would be covered, but drivers and restaurant people and other service providers would not be. And viewed in those terms, it does indeed seem like the West Virginia and Barnett case, as Robbie said, where the Jehovah's Witness students can't be compelled to salute the flag, and it could be seen as a narrow case. The dissent, though, is afraid, first of all, that there's nothing especially expressive about designing a wedding website. You just click on where you want to register, and it's no more expressive than providing a limo to a wedding. And they're also concerned that all sorts of people are going to be able to claim expressive exemptions from public accommodation laws and also religious exemptions from public accommodation laws. And although this was not a free exercise case, it comes against the backdrop of the most controversial series of First Amendment cases the court is deciding now, which is whether or not someone who's religiously scrupulous can claim an exemption from general laws. And that includes the guy who didn't want to bake the wedding cake, as well as the Little Sisters of the Poor who didn't want to provide contraception coverage under the Obamacare mandate, as well as those who are seeking very broad exemptions on religious grounds from generally applicable laws. And this is just a clash of very different visions of the free exercise clause. We had a wonderful debate at the Constitution Center on Constitution Day with Michael McConnell and Marcy Hamilton, well representing completely different views of the free exercise clause with Professor McConnell, arguing that people should generally get those religious exemptions unless there's an overwhelmingly strong state interest in forcing them to abide by the generally applicable law. And Professor Hamilton saying that's a radical, first of all, rewriting of original understanding. She claimed that at the time of the framing, most religious exemptions were legislatively granted, like when the Quakers didn't want to have to bear arms because their religion prohibits it. Legislatures granted the exemption, but courts didn't say the Quakers didn't have to serve. And Professor Hamilton says it's bad originalism and radical exaltation of religion over the obligation to abide the law if you're going to create carve-outs from all the many laws that may infringe on some people's religious scruples. So that's the nature of the debate. It was, as Robbie says, that 303 creative could be viewed much more narrowly, but it comes against that context. And then finally, the student loan case, as John said, is a statutory case, not constitutional. It all turned on the meaning of the word waive or modify. And the federal statute at issue said that the president's agencies had the power to waive or modify regulations in connection with a national emergency. President Biden said he was just waiving or modifying the statute when he said you don't have to repay the loans. And the majority of the court rejected that and said, waive or modify doesn't mean cancel. It's a rewriting of that language to allow people not to pay at all. And given the scope of the money at stake, trillions, I think, you need a clear statement from Congress before you can construe the act to allow the modification. And then the court invoked something called the major questions doctrine, which they said generally compels Congress to speak clearly if it's going to allow the executive to do stuff that has huge consequences. And this had huge consequences, and Congress should have spoken clearly and didn't. This debate about the major questions doctrine comes across against the backdrop of this huge effort that I mentioned to roll back the administrative state. And this term, the court's going to hear very significant cases on this question, including one asking it to re-examine a case called Chevron, which, since it was decided in the 80s, requires judges to defer to administrative agencies. And another case it's going to hear tomorrow, you can hear the oral arguments online tomorrow morning about whether or not the Consumer Finance Protection Bureau is unconstitutional and whether it violates the appointments clause provisions of the Constitution or not. Broadly, this debate about the scope of the administrative state will depend on your views about what the Constitution allows Congress to delegate. Those who are in favor of rolling back the administrative state say that broad delegations by Congress to the executive violate the separation of powers. Congress has to legislate, the president enforces, executes the law, and you can't mix stuff up. The counter argument is, hey, textualists, where did you get these doctrines like the major questions doctrine and the non-delegations doctrine? The Constitution doesn't say anything about major questions or non-delegations, and you supposed textualists are just making this up because you don't like the administrative state, and it's not in the text of the Constitution, and it's also not in the original understanding because the argument goes, this is the old debate about Hamilton versus Jefferson. And ever since Hamilton defended broad power of Congress to charter the national bank and said that any time a power is not only necessary, but convenient or implied, it should be granted. And Jefferson countered and said you should strictly construe the text and not grant unenumerated powers. Hamilton won that debate, say the pro-government power argument here. Chief Justice Marshall sanctioned his argument in McCulloch versus Maryland. And therefore, once again, the claim is that the textualists are trying to resurrect the vision of Jefferson, which has warrant neither in the Constitution nor in precedent or practice. So that's the nature of the debate.
Good. So we're only have 10 minutes left. So unfortunately,
We have two professors.
we're not going to get to my third question. I want to really turn to the questions from the audience. I do worry there are too many lawyers here because when you fill out an index card, don't put footnotes to the questions. Bad idea. I'm usually not going to read those. So Actually, several people have this question in mind. It's a fairly narrow question, but there's a bigger question to it, which is, do you think that Section 3, this is a section of the 14th Amendment we haven't talked about yet. Do you think Section 3 of the 14th Amendment, which here's where the footnote in the index card comes, which disqualifies people from holding office who have participated in some way in an insurrection when they were an officer of the government. Will that be used to disqualify President Trump in the next election? But there's a bigger question behind that, which is, regardless of your view on that issue, I think the Supreme Court's going to be able to stay out of the 2024 election.
Oh,
Given, Robbie said the Supreme Court's momentous and it does it regularly. Is this one of these big questions we're going to ask the Supreme Court to figure out in some way? And there is no clause in the Constitution that sets age limits on the presidency. I would just set that out right now. So, Professor George, by the way, this was
lower limit.
that was sent in by a student, by the way. I wanted to point that out. So great. So Ryan, why don't you go first and then Jeff? 2 minutes each.
Yeah. Professors Bode and Paulson have written a very interesting article. Two conservative professors, very distinguished and very brilliant, both of them, making the case that under Section 3 of the 14th Amendment, President Trump is disqualified because of his role in an uprising and insurrection against the United States. Obviously, that implicates all sorts of issues about what constitutes an insurrection and what role did President Trump actually play. What did he say in his speech before the mob went into the Capitol and so forth. I'm glad you put the question the way you did so that I can dodge the really hard part, which is this going to make a difference? No. I don't think that's going to make a difference. I don't think that the Bode-Paulson argument is going to be politically salient. If you want to beat Donald Trump, you're going to have to beat Donald Trump. You're not going to be able to disqualify him with something like this. But then you turned on me and asked the really hard question, which is, will the Supreme Court be able to stay out of the 2024 election? And here I fear that they will not be able to stay out, because there will be all sorts of, or likely to be all sorts of smaller issues than the one that Bode and Paulson are raising, that the court will likely have to either weigh in on or weigh in on indirectly by refusing to review lower court rulings having to do with particular election practices in the states. I would love, I think for the public weal, for the common good of the nation, it would be great if the Supreme Court were not dragged into this, but I fear that it's likely to happen. Jeff, what do you think about this? I'm not confident.
Because this will be, I guess we only have 5 minutes left. So just another set of things is also maybe the possibility that some of these prosecutions will get to the Supreme Court by the time.
Well, that's right. I mean, is he disqualified? Can states disqualify him from the ballot because he's under indictment? Or what if he's actually convicted before the election? Then can states disqualify him? I don't see how the Supreme Court's going to be able to stay out of that, but I really want to hear Jeff on it. Jeff.
Well, on Section 3, of course, there are arguments on both sides, and among the ones that Robbie mentioned, did he commit an insurrection or not? Professor, or rather Judge Ludig, who's argued strongly that he is disqualified under Section 3, notes that Section 3 forbids not only insurrections against the United States, but violations of the Constitution of the United States. And Judge Ludig says that President Trump did violate the Constitution, whether or not by trying to subvert the election, whether or not he committed a technical insurrection. There's also the question of whether the president's covered or whether lower officials are covered, and whether Congress has to enact Section 3 or whether it's self-executing. I could imagine some lower courts weighing in if state secretaries of state tried to keep President Trump off the ballot, but agree that in the end, Section 3 won't be the central election case. There's the question of disqualification in light of the lower court trials. There could even be the question of a presidential self-pardon if President Trump wins.
Right.
And once again, we've done podcasts on all these questions, which may not at all be academic. There's a fascinating textualist argument that you can only grant a pardon to someone else. It's not an intransitive verb, and that's because the framers, the pardon power, originally in the English king, no one contemplated it could be exercised by the king to pardon himself because the king couldn't be prosecuted because he had the sovereign power. But in America, the president is not above the law. That's the central principle of our jurisprudence, and therefore he cannot pardon himself because the framers repeatedly said that they expected he would be liable to prosecution, and the court could well decide that.
Oh, we actually have time for one more question. So the last question, maybe we'll return it back to politics because several people ask a variation on, will the Supreme Court survive this period of hyper polarization and partisanship? There was just an opinion poll out from Gallup on Friday that said the public approval rating of the Supreme Court hit 40-something%, the lowest ever in history. Although if you're Chief Justice John Roberts, you're probably saying, as long as we're better than Congress, it's not that hard to do, or journalists. But I just say that because those are the traditionally lowest ranking professions in the Gallup poll. But do you fear or worry that with all of the attention on the court now, it's all the political criticism of the court, we've had the leaking of a Supreme Court opinion, we had an assassination attempt on a justice last year. Now we have stories about justices taking trips, receiving gifts. It's hard for me to be moderate about this because I clerk for Justice Thomas. But do you think that this is threatening the integrity or independence of the court, the ability of it to continue to play the role that you both agree the court has been playing? So, Jeff, why don't we start with you, and then Professor George will finish first.
On the ethics question, the court itself is clearly concerned. Justices Kagan and Kavanaugh said just a few weeks ago that the justices are looking at ethics reforms. They're struggling to find a way out from having lower court judges review their recusal decisions, which some of them think would violate the separation of powers. But they acknowledge that public legitimacy of the court is important, that binding themselves with some kind of ethics code might be a good idea, and that they're working on it. Friends, these are very serious times for America, and the polarization that's afflicted our political system is so grave that we're facing an election that could lead to fractiousness, if not violence, unlike anything that we've seen since the 1860s. And it's urgently important that in this time, citizens of different perspectives can accept the courts, the lower courts as well as the Supreme Court, as neutral arbiters of the rule of law. And that's why it's so important not to attack judges in partisan ways, lower court judges or justices, merely because you disagree with their decisions. And that's why it's important to allow these lower court legal cases against both President Trump and Biden to go forward and to support trust that these are judges of good faith who will interpret the law fairly, and we can accept their decisions as being rooted in law. And that's why it's important, although extremely vigorous criticism of the Supreme Court is always appropriate, of course, for the court also to do everything possible to win the trust and legitimacy of citizens in these polarized times. The best thing you can do is don't assume that it's all politics. Read the decisions, including the lower court decisions involving Presidents Trump and Biden, and evaluate them in legal, not political terms, always with a presumption that our federal judiciary is trying to interpret the law to the best of their abilities.
Robbie.
The country is in trouble. This is a bad time. There are two main reasons for it seems to me, and there are reasons for the reasons, but the two main and related reasons are the extreme polarization and the collapse of trust in institutions. Supreme Court's not unique here, nor is Congress. The trust in institutions, governmental institutions, non-governmental institutions, the trust in business, the trust in religious institutions, there's been a virtual collapse. This is a big, big deal. You put those together and you have a situation in which citizens who disagree about important matters of the common good and rights and justice, citizens who disagree no longer view themselves as fellow citizens, civic friends who happen to be on opposite sides in different parties and different ideological camps. They see each other as enemies. And enemies are to be defeated and even destroyed. What did Madison say in Federalist number 10 was the real danger, the constant danger through all history to republics? Why have republics always failed? And failed in the worst way because they collapse into the worst forms of tyranny. Faction. It's the problem of faction. When we stop seeing each other as fellow citizens, as civic friends, and start seeing each other as enemies. It almost ended the country in 1800. The bitterness that we see in our electoral politics today is not new. And it goes there. We have an example of it even before the Civil War, which was the next time when the country almost came to an end. We managed somehow to get through it in 1800. People really didn't know whether the Federalist Party would relinquish power, whether President Adams would relinquish power to the Jeffersonians, the Democratic Republicans, if they lost. When they did lose, it was a real question. And fortunately, the Federalists did relinquish power. Jefferson was able to become president. There was no massive violence, but at the time, it was a close run thing, and it could have gone either way. Then, of course, there was the circumstances that led to the fratricide of the Civil War, and we're back here again. So we're going to have to do our best to rebuild trust. And here the challenge is this. There's a reason trust has been lost, whether it's the institutions of government, the institutions of religion, the institutions of the economy. People have been untrustworthy. People in authority have let the side down. People didn't just suddenly become distrustful. So, we have to rebuild that. Our leaders, the people who are responsible for institutions, have to work to rebuild, to earn back the people's trust. Number two, and this is something we can all do, and we can all set examples for other people of doing it. And that is, despite our differences with each other, treat each other as civic friends, not as enemies. Engage each other as troops. Engage each other in a spirit of truth seeking and with a very keen sense of one's own fallibility, with a keen awareness that we could be wrong. I think it was the greatest judge never to make it to the Supreme Court of the United States, Learned Hand, who said the spirit of liberty is a spirit of not being too sure you're right. Now, he was not arguing here for moral relativism or there's no such thing as truth. He was a man who had beliefs, he had convictions, he held them because he believed they were true, but he also recognized fallibility, his own fallibility. So he was willing to learn from people he disagreed with and not just spend all his time preaching at them. And I think that's a great example for us. There are two opposite errors we need to avoid. One is moral relativism, the belief that there is no truth, there's no justice, there's no right, there's no wrong. That leads to, if those of you are familiar with Plato's Republic, that leads to Thrasymachus and the idea of might makes right. It's all about power. If there's no truth, it's all about power. The opposite error is a fanatical absolutism that is so cocksure not only that there is truth, but that I've got it, that you lose the sense of one's own fallibility, and therefore you lose the intellectual humility that you need to run a republic, where citizens are supposed to govern themselves through debate, discussion, dialogue, exchange. End of sermon.
Bravo.
I think that's probably a perfect place to end tonight. Robbie George, Jeff Rosen, John Yoo. Ladies and gentlemen, please thank our distinguished panelists. Thank you.
Oh, Jeff, always such a pleasure. Thank you. Exactly.
Thank you. And we look forward to seeing everyone back here on October 18th for a great Royal Oak program. And then October 23rd, General Petraeus and the great professor Churchill historian Andrew Roberts with the great program. We'll see you on the 18th and the 23rd. Have a wonderful evening. Thank you and good night. And if I can ask our St. Joe's prep students to come up for a picture. Thank you. Have a great night.